Christina, thank you so much for being with us today.
Absolutely.
I would like to introduce you to our YouTube audience. Thank you for being with us as well. I'm here with Christina Gentilini, and she is part of a trust attorney firm. It's a family firm, Williamson and Gentilini. They're right here in Long Beach, and Christina's going to explain to us what a trust is, what a will is, why it's important to have one, how it protects you, and let's go from there. I know your time is very valuable, so can you just start by telling us what is a trust?
Yeah, absolutely. So what is a trust? A living trust is a document, a legal document that specifies who is going to inherit your assets when you're gone, and then also specifies who's in charge of those assets should you become incapacitated or pass away. One of the major questions I get all the time, well, what is the difference between a will and a trust? A will specifies who's going to inherit your assets, but is subject to the probate system. A trust is specifically designed to avoid the probate system. And the major reason why a trust avoids probate where a will does not is because when you are creating a will, the will in California, you could create a will that's in your own handwriting and it's signed. It doesn't even need a notary. It doesn't need a witness. And in fact, notary doesn't work at all in California. But it doesn't need a witness. It doesn't need a date. As long as it's in your own handwriting and it's signed, it's a valid will in the state of California. But what that will does not do is affect the ownership of your assets. Okay, so let's take a piece of property, for example. You have your home. The deed to your property is in your name. Okay, so your name or your spouse's name. The will doesn't change that deed. The will doesn't affect that deed. So if you pass away, the only person who has legal authority to actually sign the deed to give that property to someone else, whether that's your kids or whoever your beneficiaries are intended to be, there's no one who can sign. So if you are the owner and you are deceased, we have no signer. So the will tells the court what to do with that asset and who you want to be in charge, but we still have to go to court because there's no one who can sign, and the only way we can get that authority then is by getting it from a judge.
So I'm going to interject real quick. So that's where I have crossed paths so many times with Christina, is because I have worked with her and clients that have had to go into what is called probate. So real quick, can you explain what probate means?
Absolutely.
And then we'll go into the costs of probate and why it's so important to protect yourself so you don't have to go into probate.
Yeah,
okay.
Absolutely. And then we'll circle back into why a trust avoids those things.
Perfect.
Okay.
Perfect.
So why we want to avoid probate. So first, probate in California especially is an extremely time-consuming process and an extremely expensive process. You know, my firm, I do a lot of probates actually, but I don't litigate, okay? Even without litigation, even without an argument, the normal probate timeline is upwards of 1.5 years. And it depends.
1.5 years?
1.5 years, yeah. And it depends on what county you're in too, what county the decedent lived in. Some counties are longer than others. It just depends on what the court rules are and what sort of backlog they have. And so 1.5 years from the time we petition the court to the time that your heirs actually inherit.
Which is so stressful on a family, and I think that's one of the things we've both seen is that the additional stress on a family that you're already grieving and you're already going through so much, and then to add this onto it and then the costs of it.
Yeah, and the costs are very expensive. There are filing fees. Filing fees in a probate are about $500, so it's $436. But anyway, $435. Yeah. But about $500 to file to start the probate, $500 to file to the petition for distribution at the end of the probate. We have publication fees, bond fees, appraisal fees, all of those things are required in California probate. And then of course we have attorney's fees. And in California, some states are different, but here all of the attorney's fees are set by statute. And the statute is a graduated percentage. And so just to give a basic idea, I'm not going to go through the whole formula because it's kind of convoluted, but the basic idea is that if you have $1 million house, which in Long Beach, California, you got $1 million house.
Yeah.
Okay. And
pretty much anywhere in the city.
Yep. And it's based on market value, not equity. Okay, doesn't matter what you owe on the house when you pass. The market value is $1 million. The attorney's fees alone are going to be $23,000, and that's set by statute. And on top of that, if you have an executor, the person in charge of the probate or personal representative, that personal representative is also entitled to the same amount of fees.
Oh, I did not know that.
Yep.
Oh.
So if you have $1 million house, your probate is a minimum of about 50 grand.
Wow.
So between attorney's fees, the executor fees, and all of the other court fees and bond and everything else, about $50,000.
Gosh, and wouldn't it be such a gift to be able to put that money into the pocket of the family rather than have it not just go to you, but to go to the courts?
Yeah.
You don't want to have that money go to the courts.
It's the courts and the lawyers.
Yes. Wow. Okay, so as opposed to, let's say, what is your fee if someone were to be proactive and come to you and say, okay, can you handle this for my family? Can we put together the trust?
Yeah.
What are the fees there?
Yeah, so the fees really are very different depending on which lawyer you're going to. Okay, they're never as much as probate, I can guarantee that. Our fees in our office currently range from about $1,500 to about $2,500 depending on the situation.
So you're talking about, let's say, the extreme, $2,500 compared to $50,000.
Yeah. And I know some attorneys who charge more than that, but still, and you can shop around, you can find who you want, but ultimately it's still, anyone you see is going to be far less than the cost of a probate.
So there's so many questions I have. One of them being, what are people's objections? I know from my own experience that people have said, okay, I don't want to have to decide what to do with my kids, or I never have the time, or what if I don't have that money right now to put out there? What objections are you seeing? And then how can we address this with the people that are watching to say it's worth it to overcome the objections to get to the putting it together?
Yeah. I think the biggest objection or the biggest barrier that I see from clients is they feel like it's going to be a lot of work, actually.
Oh.
Because once you've created this trust, so first you have to meet with the lawyer, you have to make the decisions, which people don't necessarily want to make the decisions too, and nobody wants to think about dying. I mean, really, it's not a fun topic, and I get that. But the major barriers here are they think there's going to be a lot of work when it comes to actually funding your trust, which is a step you have to go through. But the vast majority of lawyers are going to help you make sure your real estate is covered and in the trust the way it's supposed to be. And we'll talk about what the in the trust means in a little bit. But ultimately, and then you do have to do a little bit of homework with your banking and things like that. But the lawyer is going to tell you what you need to do. I know that I send my clients home with a homework sheet. I'm like, okay, these are your next steps. This is what you need to do. And it really isn't as difficult as people make it out to be. And so I think that the biggest barrier is the thought that, oh, this is going to be this huge project. It's not a huge project. There's a little bit of work involved, but it is worth it in the long run because the amount of work your family would have to go through if you don't do it is significantly more. Significantly more.
Okay, so having seen that on a daily basis, and I've seen it enough to know, I just feel for these people. Can you give us just an example of a family that you've watched go through this and what they've had to endure?
Oh, I've had lots of probates.
I know.
I've had lots of probates. And I mean, I can't give specifics because of client confidentiality stuff, but the cost involved is very hard. We've had a case where we went into the probate and everything seemed like it was, ready to go. They're ready to sell the property through the probate. And then one of the siblings objected.
This just happened to us, and they objected the day the buyer was funding. So it was in LA County, you fund one day, you close the next day. They were going to be closed, and then they could distribute funds. And one of the family members objected and stopped everything.
Yep. And it stopped the whole thing. And ultimately, the transaction was lost. We had to go through, poor Crystal had to go through with the client to find another transaction. And actually, there was probably 2 or 3 escrows in there. And unfortunately, it's just not a fun process.
And
I can say that.
It's not a fun process. And both of us work so hard to protect the interest of our clients. But there's things that are just out of our hands.
Yeah.
out of our hands.
Yep.
No matter how much due diligence we go through, you get to certain hurdles, and that's just, our hands are tied. So then you have to stop and take steps backwards and then initiate what then would be the next move in the best interest of the client.
Yep.
Yeah, and on top of that, this was a condominium they were selling, and the HOA dues were over $700 a month, and they had to continue paying this. And initially, they were heartbroken that that their brother had passed away, and so they didn't put this on the market for quite a long time. So then by the time they went through the probate and they went through the process with the courts and whatnot, and then had the objection, and then we got it resold, they had paid for almost 18 months of HOA dues on top of all these fees and expenses. And that's just money lost, and that could have been distributed to the family. And that's really why I think it's important to tell people about this. That this is worth every penny up front to make it happen.
It is worth every penny. So other barriers are obviously costs involved with doing a trust, because it is, you're writing the check now, not when you're gone.
Right.
But again, it is significantly less than going through the probate. And then, of course, there's some people who just sort of, the barrier is that they can't decide. They can't decide what they want. They can't decide who they want to inherit. They can't decide who they want their kids to go to, as like a guardian type situation. Because the trust is just one document in a set of estate planning documents. And so when a client comes to me, we're talking through not only who's inheriting, but who would be managing your health care if you were incapacitated, who's going to take custody of your children if they are still minors at the time of your passing. So there are a lot of things that we talk through, and those topics are difficult for people. So I think my two biggest barriers are, one, people don't want to make a decision or they don't want to talk about it, and two, that they just think it's going to be a lot of work, and it's not as bad as they seem. In fact, I can't even tell you how many clients I have say, "This is so much easier than I thought it was going to be."
Oh, good, because
I hear that a lot.
Set them up for success from the beginning.
I hear that a lot.
Yeah, and Christina and I are both moms, so we get it that it's hard to make decisions on what if, for your kids, because you always, that's your greatest asset is your children. But if you made the decision and had the peace of mind that if something happened, and God forbid, that your kids are going to be well taken care of and it's handled, as opposed to what if the state had to decide? That would be terrible.
Oh, yeah. Family gets involved usually, but it's still, we want to set things up as best we can.
Great. What would be your best advice or recommendation to somebody that's considering doing this? Besides just do it. What would be your best?
Besides just do it?
Yeah.
Just do it.
Yeah.
Well, obviously, I think it's a good idea that you're going to be most comfortable with a lawyer. I do recommend seeing a lawyer. I can't tell you how many times people have done legal Zooms or other software on their own, and the trust itself, the documents may be valid. That's fine, but people don't know how to put their assets into the trust. Okay. So I do recommend, if you're interested in moving forward, definitely talk to a lawyer, and meet a few. There's no problem with that. I have clients who come in and just say, I just wanted to meet you. I wanted to see what you were like, what the firm is like, and you can shop around for a lawyer just the way you do for a realtor or
really,
for anybody
I was thinking
else.
the same thing. Yes.
So make sure go into it feeling that there's a sense of comfortability there, and just do it.
And just do it. Definitely. So Christina, let's circle back around. How does the trust avoid probate?
That's a great question. So the basic way that a trust avoids probate, and again, I'm going to explain this in a way that's not really legalese. So any lawyers out there watching this, I know that you're going to go, but I like to think of a trust like a box. So when you sign the trust document, you're creating this imaginary box that you can put your assets into. And so ultimately, when you put your assets into the trust, you're changing the actual title holder of the asset. So like, for example, on the piece of property that we were mentioning earlier, when your asset is titled to the trust, That means that if you pass away, the owner still exists, the trust still exists, and the trust document then specifies who is in charge and who has the legal authority to manage that asset. So by putting assets into the trust or into the box, we are retitling the asset. And now the title holder is not someone who can die or become incapacitated, but is instead the trust.
Great visual. I like that.
Yeah.
Okay.
And as long as someone has legal authority over that asset doesn't have to go to probate.
Great.
Okay.
So then you save the $50,000.
Yes. Exactly. Exactly.
So Christina, what is one of the biggest misconceptions about a trust?
Well, there are different types of trusts in California, but the type of trust that I'm talking about, the probate avoidance trust, and that's what we do in our firm, is intended solely for avoiding probate and making sure someone can manage things if you're incapacitated or if you're deceased. Many times clients will come into the office and say, okay, well, I want to put my assets in a trust because I don't want to get sued, or if I get sued, I want to protect the assets. The revocable trusts that we prepare in our office are not asset protection entities. So it is important to understand that you still need insurance, and if you have a business, you're still looking at corporations or LLCs to do that.
Yeah, this is not going to replace any of those things.
No, this will not replace any of those things, but it does make sure that your assets don't go to probate if you die, or that we need to get conservatorship over you or your assets if you become incapacitated.
Very good points. Thank you for pointing that out. I appreciate it. Yeah. Thank you so much for being here. I hope this helps people think about it and realize how important it is, and just make it happen. Just make it happen so that your kids, your assets, your property is protected. I know that's one thing that, because we've come across so many properties together to say it could become a hassle. It doesn't have to be if you get proactive now.
Exactly.
Yes. So we will provide information on how to get in touch with Christina and her family. And thank you so much for tuning in. We appreciate it, and make it a great day.
Thank you.